Hi, I'm Richard Kemp, and in this vlog we're looking at why software costs for law firms are rising and what does optimizing your costs really mean. If you're hit with a higher than expected software bill or your vendor is pressing you to move to the cloud, the first thing is to look at the contract so that you can see what you've got. This can be less easy than you may think. The contract may have been shoved into the proverbial bottom drawer, key people may have moved on, the vendor may have been taken over, or the firm may have merged. But even when you've tracked it down, the contract may not get you very far, as what the firm is actually using today may look very different from what it bought all those years ago. If that was an on-premise perpetual license, it's likely that the firm will be paying for maintenance annually, typically 20% of the perpetual license fee. So, how best to switch to the cloud from the on-prem model? The initial point is whether you have to think about a choice now. This means finding out from the vendor how long you've got on the on-prem system. To encourage customers to switch to the cloud, vendors are increasingly end-of-lifing on-prem systems by saying support will no longer be commercially available beyond a set date, typically a year or two out from today. If you want or have to switch to the cloud, the firm is really blending two sets of commercials which should be addressed in the contract at the same time. First, what's the deal on the cloud? The vendor will give a better price for a longer term deal and with more seats, and it may offer tiered support, silver, gold, platinum at higher prices. If, in the cloud, the firm is using the vendor's platform or a third-party platform as a service like Azure or AWS, that will be an extra cost and maybe a further contract with the PaaS provider over and above the cloud SaaS agreement. The second thing is how much the on-prem service is worth today. This is the present-day value of the balance of the perpetual license and support fees. The question here is whether the cloud provider will, in effect, part exchange the on-prem system for the new cloud service. In our experience, this ends up as a horse trade rather than a detailed financial exercise. But vendors have been receptive to the charge of making firms pay twice for the same thing, and as a result they've been prepared to contra on-prem runoff costs against ongoing cloud costs. The move to the cloud is underway at most law firms at the moment, and never has forewarned means forearmed been more apposite for law firms in their tech contracts. If you'd like to find out more, check out our website at kempitlaw.com.